of you that don't know me or Castle Group, Castle Group is one of the largest association management firms in the state, specializing in HOA and condominium management. We have over 2,700 teammates. We manage over 500 associations in the state, and we're headquartered right here where I'm actually speaking to you in what we call our home office in Plantation, Florida. So very excited to talk to you a little bit more about some of the topics that we have. And before I do that, why don't I just give a chance for Alessandra for you to introduce yourself, and then we'll go to Carlos and Rebecca.
Sure. Thank you, James. And thank you to Castle for coordinating this and Popular Bank. My name is Alessandra Stivelman. I'm a partner and shareholder at Eisinger Law, and we are a full service law firm focusing on representing community associations throughout the state. I am board certified in condominium and plan development law. I teach condominium law at NSU Law School, and this is pretty much what I do 99.9% of my working day. So happy to be here and excited.
Carlos? Carlos, can you hear us?
Hello?
Yep, can you hear us?
Oh, yes, perfect, thank you. I'm Carlos Hernandez, Division Manager at Popular Association Banking. Been with the bank for over 20 years and here to assist all association in their banking services and supported by a great team.
Thank you. And Rebecca? You're on mute, Rebecca.
Good morning, and thank you for having us. I'm the Senior Vice President Team Leader for South Florida under Carlos Hernandez's direction, working on a great team. We're here to service all of your banking needs for associations. Again, thank you for having us.
Great. Well, thank you everyone again for joining today, and thank you for everybody that's on our participation here and our registrants for joining us. I know that just to kick things off, really the sheer amount of information, the press, the discussions, it can be overwhelming, right? Especially as it relates to Senate Bill 4D and HB 1021, which we're going to talk about in a little more detail. But because of just the sheer critical importance to this legislation and the new legislation that comes out, we really believe that we need to continue to provide this thought leadership and share information to our respective clients, and even those who are not clients that we do not work with and hopefully hope to in the future. But really the goal here is in these webinars is to provide that thought leadership. And, you know, we want to become better prepared to avoid really what much of the laws and the legislation was enacted for. And unfortunately, that was for the Champlain Tower tragedy. And, you know, I was just looking at some of my notes yesterday, and it's hard to believe, everyone, that it's been over 3 years since this event occurred. And I cannot believe how quickly time moves on that front. And, you know, we had, after that tragedy, we had Senate Bill 4D come to the state in 2022. And we all know that those requirements for the condominiums that were over 30 years, the different milestone inspections, the buildup, the funding requirements, and the timing of that, which, of course, the funding mechanisms for these must be completed by December 31st of this year. But I think specific to HB 1021 is actually building upon that previous legislation passed as a result of the Champlain Tower collapse. And more specifically, there's some language for what the requirements are. And of course, we're going to talk through some of these things, but, you know, there's increased educational training. There's transparency and disclosure requirements, penalties for failing to keep certain records, posting of those records, and so on and so on. So there's a lot of things that are subject to interpretation, and that's why we have Alessandra and great partners to help us have a little bit more clarity with some of these things. But I think for today, we probably are going to spend a little bit more focused time on actually SIRS, fiduciary board obligations, the reserves and the lending and the funding of those reserves. So I think with that little preamble, why don't we kick it off? And Alessandra, I think I'm just going to hand it over to you, and maybe specific to you, you can spend some time kind of going through in more detail on what the actual CSRS and reserve requirements and some of the additional legislation that's important for our registrants to be aware of. And hopefully we can come away with better preparation for 2025 and beyond.
Right. So I have very little time to cover what I know we've done in 1 hour, 2-hour webinars. So I'm going to try to speak slowly, and I know I'm not going to answer every question out there, but essentially, as James mentioned, HB 1021, this is the condo bill. It's the third round of glitch bills after Champlain Tower and the legislative updates. It was signed on June 14th and became effective July 1st of 2024. And like James mentioned, it deals with community association conflict of interest disclosures, CSRS requirements, board meeting requirements, new record retention policies, conflict of interest for board members, hurricane protection, prohibition on SLAPP suits, multiple or multi-use condominiums and shared facilities. I mean, we can focus on any of this, but really the big thing that I think a lot of owners who weren't following it were expecting it was that the CSRS requirement would be postponed. And ultimately everyone was waiting to see the can get kicked down the road a little bit more. And that's not what happened. So to understand CSRS, after the tragedy, the legislation came in and said that the association needs to have a structural integrity reserve study. If you're 3 stories or higher and you're a condominium, a co-op, you need to comply with this requirement. So what is a structural integrity reserve study? It's a visual inspection that has to be performed or verified by an engineer or an architect that's licensed or a certified reserve specialist. Now, if you guys think about how many condominiums are in the state of Florida and how many actual reserve specialists or architects and engineers that are there to do this, one of the problems that we're facing is supply and demand. There's a huge demand for these services because everyone's realizing, probably can't curse, but like, oh shit, now it's a time I have to do it. And now they can't get vendors to respond quickly enough because they have a backlog. The part of it is you do this inspection reserve study, and they're going to look at roof, structural aspects, fireproofing, plumbing, electrical, waterproofing and exterior parts, windows and exteriors, and then anything else that is structurally related that has a replacement value of over $10,000. So in a nutshell, and simplifying in this a lot, those are your structural items that you're going to get a CSRS study. Structural Integrity Reserve Study is what we all call CSRS. And if you, as a board member, fail to obtain a Structural Integrity Reserve Study, it is considered a breach of your fiduciary duty. So that is something that was added this time around. The CSRS has been there. It's been changed a little bit. And it applies if you're a condominium association existing on or before July 1st, 2022, you must have a CSRS completed by December 31st, 2024. That's in a few months, guys. So if you're on here and you haven't done a CSRS, you haven't discussed it, and you qualify or you're not sure whether you need to or not, that's when you contact your attorney and management and start reaching out to the resources. So the additional changes was that now the CSRS have to be distributed to the members. And within 45 days of getting it, and you have to submit it to the division, which is going to supposedly put out a list and keep track of which associations have complied with the Structural Integrity Reserve requirement. Also, developers of new construction are now required to get a CSRS before they turn over. So all these requirements are being added onto the statute, requiring and reinforcing the importance of getting the Structural Integrity Reserve Study before December 31st, 2024, and thereafter every 10 years. Now, why does this cause so much, rumble, and why is everyone so worried? The study itself is not the end of the world as far as price, but it's going to determine the life expectancy of the components that are structurally related to your condominium and your buildings and determine how much you're going to have to replace it or repair it when its life expectancy ends. So it's going to calculate. And if you've never had reserves before and you have 0 reserves, you're going to have to be fully funded at your next budget. So there's a little bit of a controversy as to when this requirement kicks in. The statute says that in a budget adopted by an association that is required to obtain a SERS, you cannot waive the SERS if your budget is adopted in 2025. So certain positions have been made or have been taken that if you adopt your budget in 2024, you don't actually have to you can actually still waive SERS. Well, but if you've taken a SERS and you've applied the SERS to your budget, you may not be able to. There's a lot of different ways that associations are looking to still kick the can down the road or avoid the funding. And a lot of questions regarding pooled reserves. Can we still pull the structural integrity reserve studies? Can we not? And a lot of uncertainty. But the other aspect of this is that before, associations could waive reserves by a majority vote after quorum. So all you needed was a quorum of the members. Let's say a majority of your condominium could come to the annual membership meeting. You'd likely sign a limited proxy and you'd agree to partially or fully waive all the reserves. And the reason that we are where we are is because a lot of condominium associations did this for so many years, where now there are no reserves and we have to start funding. But the statute was changed as a result of these legislative updates from Champlain and the Surfside incident, that you now cannot waive SERS reserves, period. Not waivable. Structural reserves, you have to collect in full. So once you get that SERS studies, you're going to have to start funding according to the reserve study. And then for the other reserves that are not SERS related, you could waive, but it's not as easy as a majority after quorum. You need to have a majority of the total voting interests. So the requirement have been, tightened a little bit, making it a little bit harder to waive the reserves and prohibiting waiver of SERS reserves. Trying to think if I covered most. Oh, fiduciary duty. So I mentioned fiduciary duty briefly, but ultimately, you have, as a board member, you have a fiduciary duty to act in the best interest of the association, the duty of care, to act with, I'm forgetting the exact terms right now, but the duty of care to act like an ordinary prudent person would, and to use your reasonable judgment. And ultimately, you're expected to do so as a board member. So you're expected to comply with the statutes. You're expected to allow inspection of records. You're expected to obtain the reserve study and the milestone inspection because someone told you that you need to and your condominium is required. But a lot of times board members don't, and there's very little remedies for the owners. The statutes have been modified significantly to create additional fiduciary obligations. I mean, it's there straight up. You cannot, if you fail to do a SERS, you're in violation of fiduciary duty. What the consequences will be, I'm not quite certain because we'll have yet to see. But there's also a lot of criminal penalties that were added. Not that, violating the statute wasn't already wrong, but now there are certain items that if you knowingly, willfully, and intentionally not disclose records because you're trying to hide something, you can be found liable of second-degree misdemeanor, first-degree misdemeanor. There are specific categories that were specifically added to Chapter 718. And a lot of conflict of interest disclosures for board members. And if anyone didn't know what a kickback was, now it's defined. So make sure you're not getting kickbacks. I don't know how I'm doing with time, but I think that was a pretty good overview of what we're looking for.
It was great, Alessandra. Thank you. And it's really helpful information because, again, sometimes there's confusion even amongst more clarity on the legislation, right? I mean, and it's a great point on, the supply and demand. Like you said it, you've got to get ahead of it, and time is ticking. And that's part of our job too. But the other thing you mentioned, and that's just a question for you, for non-SERS related reserves, does the condominium documents state, and if they do, does that supersede the majority of the requirements? Like if it's, 51%, if it's 67, if it's whatever?
I think that would depend on whether you have Kaufman language and go down that whole rabbit hole. However, I haven't seen many condo documents that specifically talk about the requirement to waive reserves.
Yeah,
And remember, the board has to adopt the budget with fully funded reserves by law. You have to
Mhm.
determine the reserves. What happened before the SERS is that boards were willy-nilly determining and throwing out numbers, and you have board members that are biochemists that are, they have no experience with construction or value of services, determining what the repair and life expectancy and cost should be in the budget. So now you're required to have a professional do it and you're required to comply, but the board still has to adopt it for everything. So if I have a lot of associations that are doing SERS and non-SERS reserve studies, because while
Right.
they're at it, why not get someone to actually tell you what the life expectancy of these components of the building are?
Okay. No, that's great. It's very helpful information. And you talked about, some of these requirements when we talk about reserve funding, and that's a perfect segue for Carlos and Rebecca to dive into. Maybe what we do is we'll start with you, Carlos, is let's talk to you about the marketplace, right? Like you're in the business, right, of providing the association's options on the different lending facilities and loans, and maybe what they can plan for and obtain coming into 2025. So I'll kick it over to you.
I'll take it over. So what are we seeing in the marketplace with associations gearing up for 2025? We are definitely seeing larger loan requests. The loans used to be maybe $10 million. Now we're seeing 20, 25, 30, 35, even $40 million loans. With that said, of course, we're going to ask more questions. We're still entertaining these loans, but we're asking, do you require a unit owner vote? Will you have a due on sale once you pass a special assessment? Meaning that if you have a special assessment with the sale of a unit, your entire special assessment will be due at time of sale. We're also looking at the units, the whole building, how many units are free and clear. We're asking, this is not that much, but we're asking for down payment. Perhaps we're not lending you the full 100% as we've always done. And we're also looking into asking or requiring for the special assessment to be passed up front for the entire term. We are definitely, again, looking for larger loans, but one good thing that we have is that we go long term. Our longest term used to be 15 years. Now we're seeing more like 20, 25. We have about 2 or 3, 30 years. We do lock the rate for you up front on the line of credit to convert to a term loan. So we take all the risk at that. But now with rates coming down, we are getting more and more requests to perhaps have variable rates on the lines, and for the rate on the term loan down the road, when it converts to a term loan, we are locking the rates at conversion. So that's pretty much what we are seeing out there. But Carlos, do you have anything to add to what I just said?
Yeah, thank you, Becky, and thank you, James. As you mentioned, James, the industry is obviously changing from what has occurred over the last 5-10 years. As Rebecca mentioned, deals are getting larger. We're here to assist the community. We're making sure that the impact not only on the associations but really on the community itself. There's a lot of pain points right now. It's sort of like this perfect storm of expenses. The reserve studies will be an important aspect of the credit considerations. Credit will be looking at some of these reserve studies and the components and useful life, and making sure that everything is aligned with what's expected as far as the useful life of components, and making sure that when we provide a loan to an association, that it's something that not only works for the bank from a risk appetite perspective, but also looking out for the associations and the unit owners as well. Sometimes we get into a lot of conversations with boards, and boards asking, why are you requiring this or why are you requiring that? We're looking at this holistically, right? We want to make sure that not only we're doing the loans, but that we get repaid on the loans, and that the impact on everyone across the board is manageable. A lot of these issues are issues that we all deal with, and just because we're lending the money doesn't mean we don't have a vested interest in making sure that that community comes through and fares well in the repayment of that loan and doing the projects that need to get done.
Carlos mentioned about insurance. I forgot to mention, go ahead and mention about the windstorm insurance and the importance.
That's one aspect that's changed, particularly over the last 2 or 3 years with rising costs on the insurances. We are mitigating. There are cases where associations have come to us and are not necessarily fully insured and underinsured, and we've had to get creative with our approach because the reality is loans need to get done, and there are certain aspects to the insurance business that would make it cost prohibitive both for the association and added risk to the bank. So we do look at ways to make deals done, get deals done. We're not here to just take the cookie cutter deals. So we've had to get creative over the last couple of years on insurance, on the insurance aspect of particular loans.
But we want to thank you for this opportunity, and we're always here to help you. You can reach out to us directly. We're always here to help you out. Thank you.
We appreciate that. You've been a great partner. And maybe just a follow-up question. I was just thinking about, as the landscape has changed for lending and the lending requirements as it relates to Senate Bill 4D and HB 1021 and the underwriting that banks go through, whether it's Popular or others, but the underwriting has the change in underwriting to qualify, are you looking at things more than just the security and size of the building and the asset? Are you looking at delinquency and cash flow and the ability to repay? Are those much more difficult now, or is it more difficult or easier to obtain, whether it's a line of credit or a hybrid loan or whatever the products out there for these assessments and construction projects?
Go ahead, Carlos.
The bigger impact that we have seen lately is the payment increases, the percentage of payment increases, because obviously as these projects have become larger, that's really one component that's a credit factor that I would say probably carries the most amount of weight when considering a deal, are these payment increases, because this is a long-term. I consider this like a long-term marriage, right? When we get on board with one of these large projects and we're in it for 15, 20 years, we're not just looking at getting the deal done and what happens in the next 2 or 3 years. We're looking at the longevity of it. So payment increases are a big focus from the credit aspect. There's other aspects and there's ways to mitigate that. But unlike on the commercial side of the banking side, right? We don't have collateral.
Yeah.
We don't take the building as collateral. On the commercial side, they can get away with some things and looking at some ratios a little bit wider because they consider the collateral aspect of the building, right? That they take on the commercial side. Whereas on the association side, we don't have that. So it's in some ways could be considered or perceived riskier, but the reality is it's not, because you're spreading that over how many unit owners. But
and we go long term, and we lock the rates. All of that helps when we have these large loan sizes.
So I'm going to interrupt here because we had a question that's directly on point to what you guys are talking about as to what is used for collateral for a line of credit. So you say there's no collateral, but it's not a physical property collateral, but you get an assessment for the lien rights. So in
future cash flow, yes, future cash flow of the association.
UCC 1 on future assessment payments.
Right. So, and essentially because you have you get a collateral assignment of their assessments, a lot of times that in those documents provide you the right to foreclose and to collect on behalf of the association if the association doesn't. So association loans tend to be the safest kind of loans because you're always going to be able to collect.
We don't have but we wouldn't foreclose. That would be the association.
The association. Right. But ultimately, like the end remedy, I've never actually seen it being done, but the end remedy is that, which is why it's so
overall they're pretty safe. Yes.
Right.
Yes.
But that's like collateral.
And that's what affords us the ability to look at these loans and put loans on the books for 20 and 25 years, unlike in the commercial space where they're much shorter.
Right.
And also these loans to associations, although they're long-term, they do have an average life. For example, 15-year loan typically is paid off in 9 years, 10-year loan is typically paid off in 6 years, and so forth.
Okay. Well, that's good dialogue, and thank you, Alessandra, because I forgot about our little Q&A chat box. So
I've been
you
trying
all-
to answer questions as I go, but
yeah, you all have been doing a great job, and Jessica's helping answer questions too as we go. And we'll have some time at the end, everyone, as we mentioned, for a little Q&A. But Carlos and Rebecca, thank you for that.
Thank you.
It's helpful to understand, and it's spurring up some more questions from our registrants. So that's always what we want to see, is hopefully we're providing some answers to that. Maybe I'll just jump in briefly for the sake of time, but talking about us as management and for us really how we navigate and help our communities and board members in these times. And I think what comes to mind first and foremost is just making sure that we promote the tenants as a management firm for. We want to communicate early and often. We want to make sure that there's alignment. We want to make sure that there's transparency. And when you communicate, when you're aligned, when you have transparency, then you have a little bit more harmonious environment because people feel that they're in the loop and in the know. And it's really critical for any vendor, whether that's management or others like yourselves. And I think the other thing is we want to make sure that we're providing strategic options for everybody. And when you do all these aspects, not only do you have that increased awareness, right, but it provides for having some optionality in the end. Do you have a plan? Do you have a contingency plan? Do you have a backup plan? And the key is having those options. So, the goal for us in association management is making sure that our board members at the end of the day have as much utility and useful information and working with and from the right vendors so that in the end, they really can make the best business decisions for the community. And that's, one of the drivers we have as association management company. And we know that, right, it's not always going to be 100% buy-in. But in the end, the majority rules and wins, and that's why we have boards and votes to take place. But to me, that's really where, for the vendors that are on here, when we talk about Popular Bank and Eisinger Law, I mean, that's where these vendors and us can have an opportunity to shine because we're working together as stakeholders. We're working together more so as partners to help the board and help homeowners in the community really navigate better in these uncharted waters. So, I think that that's really a common pain point, is that there's a lack of transparency. And there's a lack of importance to the association matters. So steering and leading these strategy meetings, the short and the long range planning that needs to take place, and really challenging constructively everything, but challenging, what does good look like and what are the best paths to take to allow you to reach that business success. So, for us in management, I know speaking for our esteemed partners here on the webinar, it's making sure that we all come together in the same room, have these discussions, have these meetings. And the big takeaway for us is that it's a proactive approach and not a reactive one, right? That's the key, is that there's a sense of proactiveness, and that's really what we're promoting and pushing. So with that, I think, Alessandra, we had talked a little bit about the legal elements of condo terminations and some of those nuances. And I know that it's not happening mainstream and happening often. Maybe it will. I don't know if anyone knows the answer to that, but is there anything that you might want to bring up as it relates to, again, the legislative updates and options that associations are considering or may need to consider?
Yeah, no, absolutely. Before I do that, if it's okay, I wanted to kind of answer, I think a lot of the questions are asking about deadlines and fully funding and when. So let's say you adopt the mindset that if you adopt a budget in 2024, you don't have to start fully funding your CSRS. And you only have to do that for your 2025 budget, which is going to be adopted in 25 for 2026. Arguably, by 2026, if you have a component that is due to be replaced because it has less than 1 year life expectancy and you have zero reserves for that component, you would have to get that fully funded. But if you didn't have to get it fully funded, you would have to pass a special assessment or get a loan or do any of those other options regardless. So hopefully not all your components are due to be replaced at the same time, and you've been doing some maintenance and replacement and repairs during the operation of the condominium so that you don't have to be at the point where you need to fully fund. But ultimately, that's it. And if you have the option to wait until 2026, why not start funding it in 2025 so it's not that much of a shock in 2026? And that's really what we're recommending, because a lot of associations are, again, they don't want to hear the owners complaining. They don't want to deal with the foreclosures. They hope things are going to get better. So they're just pushing it down the line, pushing the can down the road a little bit longer. Terminations. It's a whole loaded topic, but I think an important one. So we're seeing a lot of it in South Florida, a lot more bulk purchases and developers wanting to come into the South Florida market. There are circumstances when developers are approaching owners directly, other circumstances when they're actually going to the association, because they can say, hey, association, your SERS is going to cost you guys so much, assuming they have a SERS and assuming it is going to cost them so much, that we're willing to work something out where we buy out all the units. And it doesn't make sense for you to do, the reserve study and then collect reserves and repair this building, because the building is just not going to survive much longer. It's old construction and needs to be knocked down and rebuilt. And a lot of times, well, I guess not a lot of times, more often than not, now I'm seeing that collaboration between association and developer, and then associations are not really sure what their fiduciary duties are, and do they support it, do they not, do they provide a platform? A lot of issues that come with it when they're approached by a developer or an owner, a bulk owner that wants to buy a bulk individual units. I think there's a lot to be concerned about if you're in an association that is being approached by developers or bulk buyers that want to do a buyout. I don't like surprises. So if I'm an association and I know what's going on, I want to know the contingencies. I want to make sure that the owners, that's the best way to really protect your owners, is to make sure you understand the end goal and if you're really getting the proper valuation. A lot of times developers try to buy out units one by one and negotiating individually, and they're not taking, they may be more than your market value of your specific unit, but it's not taking consideration the value of the land if you were to get an appraisal and then market it all together. And depending on the size of the condominium and the type of owners, a lot of this seems like an impossibility for some larger condominiums, but we're seeing more and more the attempts and the sometimes unit owner led termination, which is a new concept, because it used to be you can do the optional termination and you can do termination in the event of economic waste, but I do foresee a lot of change in the legislation to make terminations in the event of necessity due to economic waste, or in the event that it doesn't make sense to afford the SERS and the MERS and the repairs, where it makes it a little bit easier for owners to make an educated decision and not such a hurdle to jump through. We have the issue of Biscayne 21 and the pending decision that's still there, and it's causing a lot of pause for developers here. I don't know how much of this sounds familiar to you guys and to our audience, but essentially that condominium had in the declaration a provision that you needed 100% approval of the owners in order to terminate the condominium form of ownership. And the developers and owners that were working together ultimately amended that provision to reduce it to the statutory requirement of 80% approval and no more than 5% objection. It went to an appeal, and the appellate court, yes, the third DCA found that the amendment of that provision was the equivalent of taking away their veto vote. And you couldn't do that without 100% approval to amend that provision. And that's a big impact because a lot of developers and bulk buyers have been buying out units with the intent to rely upon the 80-20 or the intent to amend once they get a majority to reduce that. So there's been a lot of input with the courts. There's a motion for a rehearing pending, that I'm aware of, and I think that's going to have a huge impact on the landscape for terminations moving forward.
Wow. You bring up a good point, Alessandra. I was just kind of thinking to myself, and I'm generalizing here, but for these condominiums that, 50, 60, 70 years old, fixed income or not, and as you mentioned before, they've been kicking the can in terms of funding of reserves, and now you have all this coming. Is there a path? Is there, a workshop? Is there a means where, if it does make sense to dissolve and have a dissolution or a termination, and it's the best thing for the majority of the homeowners, it's such right? And unless you've been in the development world, you really don't know the path and the steps and the risks to take. What do you do?
It's hard enough to get two people to agree on something, let alone a whole bunch of unit owners with different goals. Some people say, I want to die in this condominium, because it's very difficult to buy the equivalent, even if you get above value for your unit. If you're waterfront and if you're in a very, nice area, you're not going to find the equivalent nearby.
Right.
So it is creating an issue with owners that just say it's not worth it for me. Others are hungry to sell, and they want to make the profit and move on because they don't want to have to keep paying towards repairs. And
Right.
I think there's a lot of confusion right now. There's a lot of uncertainty, and there's a lot of different tactics that bulk buyers are utilizing in order to infiltrate these condominiums. And I think there needs to be a lot of caution with what owners agree, a lot of education like we're doing here, so that the owners understand a lot of these contingencies. You likely will not be able to sell your unit during these contingencies. You're going to still have to continue operating your association and paying your assessments. You may be out of luck if the developer doesn't get the approval from the city and they decide to pull out with no damages left and still have to do the SIRS and everything else. So a lot of risk, a lot of considerations, but I think it's going to be more, I'm hoping it will be more of a feasible option for the buildings that truly do need it.
Yeah, it's interesting times, because to your point, it's uncharted, it's complex. There's a lot of regulatory, there's a lot of condominium and legislative driven things to proceed with. And at the end of the day, like you said, if you have all things checking the boxes and the majority wants to do this, you bring up the point, which is, where are you going to move? So unless it's really a substantial increase to the market value, you have to find some place which is also going through the same issues of price and affordability. So it's a really tough dynamic.
What we saw with Biscayne is that all it takes is one or two owners, right? I mean, they've stopped the process, and now the building is sitting there and it's an eyesore and it's not occupied, and they're stopping everybody else. So when you need unanimous approval on anything, it almost makes it an impossibility down here. You need the banks, the lenders, you need to notify everyone, you need to pay it. It's a very expensive concept too. I mean, I wonder if you guys would be willing to give loans to go through the termination process.
It's really interesting.
It's funny that you mentioned that. One of the other issues that the bulk buyers adds to the complexity of this is that now all of a sudden, if that bulk buyer owns 60%, 65% of the units, and they can't fulfill the termination based on, let's say, these court rulings or whatever may come of it, now the building says, okay, well, we've got to do our projects and our restorations. Now they come to the bank. Well, guess what? Now you've got 60%, 65% of the units that are technically not owner occupied. They're in essence rentals. So now you've got an issue getting funding in a building where you have a bulk buyer sitting there that says, I want to apply for an association loan, even though I own 65% of the units. That's not going to help the situation when getting funding.
And it's unfortunate for the owners, the other 35% that need the loan in order to fund it, because the bulk buyer likely can just pay for it and wants to take it out on behalf of the association. it's a problem. And, you know, the SERS and the reserve requirements, all of this is adding to it. I mean, we're seeing that the condo market and the units, it's impacting the real estate market in Florida, because the more that these special assessments get passed and reserve funding gets increased and not waived, people with set incomes or in the 55 and older communities, or, you know, maybe they could afford the $1,000 assessment a month, but they're not going to be able to do the 2 or the 3,000, and now they can't sell. It's a problem.
It really is. It's and this has been great dialogue. We're kind of at the point typically where, you know, we open it to a little Q&A, and by the way, everybody's been doing a great job of being responsive to the questions that come in. I can see that some of them are being answered live, some of them we'll get to. So I think if we take the next 10 minutes or so that we have for the webinar, we can go through any of these and actually answer them. We can state the question and we can answer them live so that we actually have that dialogue going through. One of the things that I just saw here, which I can't legally answer because I'm not that attorney, but I think from a generalization, you know, the question came that says, why would anyone serve on the board with all the increased liability and criminal penalties? And so what happens? Can you dissolve the board, right? And so before I pass it to you, Alessandra, I will say this. Well, we are so thankful that we have board members, or else I guess we wouldn't have a job, right? So we do want you to serve. There is a great benefit to it, but it is a valid point, right? Like, if part of this new legislation said that there's, you know, personal liability, if there's increased liability and be held criminally liable, like that's a serious thing, right? So how do we help our homeowners understand options for protection or what it really means at the end of the day?
That's a great question, and we're seeing more and more of it. A lot of questions from boards like, what happens if no one wants to run? What happens if we have no board members? Well, then you're going to be, any owner can go to court and ask for receivership, and then you're going to be paying a professional significantly high attorney's fees to act as your board, and then eventually have to appoint owners. Because remember, when you're in a condominium, you own your unit and your percentage of the common elements. So you guys are co-owners. That is the type of ownership that you purchased into. So ultimately, if you're not going to do anything, someone will, and there's going to be likely a receivership appointed. Now, it's usually the rarest, it's usually the choice of least, like, last resort. You don't want to go to a receivership, but how do you protect yourself as a board member? You use your business judgment rule, and that includes getting educated. That includes reaching out to your professionals, getting legal advice, using qualified management, using the professional for each specific issue, and ultimately memorializing it. Show that you're having those meetings, follow the statute, have the minutes document the meetings, post those notices, make sure you memorialize, as a board member, I would never want my personal board member email mingled with my work email, because while there may be things that are restricted from records inspection requests, perhaps, if I'm subpoenaed or if the association is subpoenaed, they're going to have all my work stuff, right? They're going to have all my personal stuff. So I always recommend set up a different email for president@hoacondo.com or whatever, and start keeping those records in a way where you can use the records as a CYA and you protect yourself. Because at the end of the day, everyone's always looking for someone to blame, and you're doing your best and you're utilizing professionals. If you make a mistake, it's okay. It's just a matter of not continuously making mistakes, turning the other way, and being intentionally negligent or willful, not acting in the best interest of the association, which is a really high standard to get to. But, in Florida, I think especially in South Florida, we see a lot of people getting away with it for too long, to the point where we've had to define what a kickback is and explain specifically what it means to get something of value without really providing any services or anything, and what you're not supposed to be doing. And owners and board members don't really understand that in co-ops in different countries, the board member is hired, they live in the building, they run things. And a lot of people that come from other countries, because we're a melting pot of cultures in South Florida, there's a lot of confusion as to who is responsible for what. So education is how board members protect yourselves, educate your constituents. It's just like a mini government. If everyone understands why you're having to pass that assessment or get that loan, it will be easier to swallow the pain because it's doing what you need to do.
That's great stuff. Carlos and Rebecca, do you have from the chat group anything that I can see some of these coming in that are related to?
I've got one regarding, so there's a question, if associations take out a loan for 10 to 15 years, they can never get out of the hump to just have reserves where they need to be. It's a circle. Better to ask the unit owners to take a loan out and pay for the assessments. We're seeing a combination of that. Obviously, unit owners that have the means that do not want to participate in a loan and want to pay the assessment up front. So we're seeing a combination of that. It's not always that the membership, 100% of the members participate in the loan. What reserves will do in the future, though, it will provide the funds so that the loans in the future will be much smaller. I think what we're seeing now is just sort of, as I mentioned earlier, sort of this perfect storm of all of these things coming together. The deferred maintenances that have occurred for so long, boards that have kicked the can down the road, and unfortunately has come at a time where you've got reserve, obviously the legislative imposed reserve, you've got the insurance issue. It's just the timing of this, but I believe in the future, loan sizes will come back down to a much more manageable size as associations have these reserves in place and really will just fund maybe the gaps in you set a number today based on a reserve study, costs maybe increased differently than what you planned for, and then when you get there 10, 15 years down the road, you may have a smaller gap. I think that's where the loans will come in to fund the gaps, where I think right now what's happening is the loans are funding the majority of the projects, some cases 100% of it. In the future, I think it'll be the reverse. I think bank loans will be there to fund just the gaps.
Interesting. And Alessandra, there's some questions here, and I'm not going to infringe upon my unauthorized practice of law. So I'm not going to attempt or try to be an attorney. So we have about 9 minutes left, and so many of these are great questions, but they really fall into your bucket. And I know that, Alessandra, you're answering these live as we go to some of these people. And I just saw one that came in, which probably is a more broader question. The legislation is specific about who it applies to, but 2 stories, 2.5, 3 stories, like some of these little subjective things. And I think, you bring up a good point, in which we always do, which is refer to your association attorney, and that's your best path. But in the absence of that for now, is it pretty black and white and straightforward on who it applies to and who it does not? Or are there a few things that's like, maybe we fall into this gray matter? I'm not sure.
I mean, think about buildings that maybe are 2 stories and then they're still joined, but then become 3 or 4 stories. There's always issues. There's no, clean cut. But the general consensus is the SERS requirement applies to buildings 3 stories or higher, residential. It does not apply to, actually, wait, no, I take that back. Let's not go into that, but 3 stories or higher. And then everything else, talk to your attorney, because it's not that black and white. A lot of the deadlines may change a little bit if you have your milestone inspection coming down the pipeline as well. So it's never black and white, especially with these requirements. But I think that for board members, what they need to be doing is understanding what they are. I know our firm does legislative updates. I know a lot of firms and management companies do too. They're available online for free. Everyone does it differently, explains it differently. Usually for me, it takes me hearing it and reading it several different ways until I can digest it. And I
Mhm.
know that what we're talking about, unless someone has some kind of basis, it's a lot of information. And I highly recommend, attend the board certification course, even if you're already certified, attend the lunch and learn so that you can understand it's hard to talk about the individual differences here because we have over 200 people and it's all varies, but
Right.
and even if you're not required to do a SIRS, maybe when the demand is not so high, wouldn't you want to know if you're properly putting away the right amount of reserves? Wouldn't that be part of your fiduciary duty to determine and have a reserve study, maybe not a SIRS, but a reserve specialist tell you, this is how much it's going to cost to redo your roof. This is what the life expectancy is. This is what I recommend. And then you follow that recommendation. And if we're talking about how do we protect ourselves, rely on the recommendation of professionals.
Yeah, that's a really great point. Because you have different needs, but at the end of the day, you're still talking about legally required or not, what's a best practice?
Right.
What are you doing to help the betterment of your community, whether it's the physical plant or the rules or the living experience? And so those are the things I think we're all, whether it's in lending or in legal or in management, as we're promoting, there's a method and a methodology to implement what's the best thing to do. And you make a great point. Like if you think that you're in the gray matter and it's not so black and white and you have legal counsel, well, plan for doing it either way. You want to know the useful life and the expectancy and all the things that can help you mitigate risk at the end of the day. So that's a great point you made. And some of the other questions that come up too from our chat are asking about county by county basis rules, right? So you have state legislation and then you have representatives that are coming out and saying, well, is it different per county and some of those things? So I know that a few questions came about that. Is there anything, Alessandra, that you may want to generalize?
So the county and the local requirements apply more to the milestone inspections. Miami-Dade County and Broward County have always required milestone inspections type. Now it's been formalized, and so the entire state now needs to do this first step and then possibly second step of the milestone inspection when the building reaches a certain age. And we're not going to get into it because I'm going to get a million questions about it if I start giving you guys deadlines. But there are certain extensions based on the county and city, and if you're already doing some of the work. So the statute does address it, and I recommend if that's your case with milestones, take a look at it. SIRS was barely touched with the new legislative update. They added disclosure requirements, they added distribution requirements, but the deadlines were not changed for SIRS. So that was a big shock. And I think that there's been I get news breaks all the time about everyone's comments on what's going on in the South Florida condo market and what's going to happen. And everyone's calling for a special session, but I don't really foresee that happening until we have these glitch bills drafted. And, it's important for us on the ground to talk about these issues and hopefully for them to make their way up to the legislature because we're really experiencing it. And it's not a one-size-fits-all solution. Every association is unique. They have different needs, and it really requires a team of professionals to work with the board and determine what makes the most sense moving forward.
Perfect. And you mentioned another thing too, which is what is your thoughts, just generally speaking, about relief? Like, is relief and aid coming? And if so, what would it be? Would it be federal or not? Like, so far, nothing has been really centered past on that front yet, right?
Well, there's the pilot program for hurricane protection for condos. But aside from having a board meeting and approving the application, if you're actually going to get the grant, you need to have unanimous approval. And you guys know how I feel about that, which is virtually an impossibility unless you're talking about a really small condo. But in Miami-Dade County did create, and they've been very effective with allowing owners to take out, to apply for grants and different assistance and loans, I think, from the county to assist with special assessments up to $50K. I don't foresee there being any statewide assistance coming down as much as we would like that. I think mostly it's going to be local, and it's getting the legislature to draft something that we can implement. And there's I don't know what the solution is.
Yeah.
Yeah.
And that's the.
If anyone does, let me know.
Yeah, well, that's what we keep on talking about as part of a theme is it's uncharted waters on many things, right? And things are still going to evolve and come. And that's why we're trying to be as proactive as we can, make good business decisions at the end of the day. And that's why we have great vendor partners like yourself. And I think maybe that's time for our conclusion here, right? We've got one more minute. I did want to mention just for everybody that's participated on this call, I want to thank you personally, Alessandra and Carlos and Rebecca. Thank you so much for spending the time today. This was fun. We definitely need to do it again. And I did want to thank the registrants that came. This was great questions, great dialogue. We've got a number of questions that still are coming in as I'm speaking, I can see. So what we will commit to is you have the contact information for Popular Bank, for Eisinger and Alessandro, Rebecca Keller-Silveira. You can see that. And of course, we have all of our registrants. So we will follow back with each of you for questions that you have. And we'll make sure that we get those answered so that we can, still be responsive to you. And hopefully we'll do this again. And then lastly is just this information here. If you enjoyed it, if you didn't, please send us comments, like us, share us, do all the things that you feel are important for us. But these are the things that we want to become more involved with as thought leaders. So thank you everyone for participating. And with that, we'll conclude. Enjoy your Tuesday afternoon and so long, everybody.
Thank you.
Thank you, everyone.